I am Dr. MP Changappa. I teach at NUJS as an assistant professor. Today I am going to discuss about environmental crime in India. The word environment comprises many the aspect: air, water, flora, fauna, wildlife, etc. For each and every the aspect, when you look at the environmental law as a whole, different laws have been enacted by the government. For example, Air Act, Water Act, Biodiversity Act, Waste Management Regimes, Environmental Protection Act. In each and every the provisions of the law, we come across penal provisions which deals about various aspects relating to crimes. Prior to the Constitution of India 1950, couple of the other laws were existed in India which regulates environmental crimes. For example, Elephant Preservation Act, Cattle Trespass Act, and also Indian Penal Code, which dealt couple of the provisions which prevents the environmental crimes in one or other methods. Whereas after 42nd Amendment 1976, the forest and wildlife moved to the concurrent list, wherein central government came out with a number of the regulations on environmental aspect. For example, Air Act, Water Act, Environmental Protection Act, Biodiversity Act, and Forest Conservation Act, which made certain activities as crime in India. For example, the Water Act, we come across lot of power have been given to the Pollution Control Board, and whenever the Pollution Control Board gives consent letter to start industries, the industry shall obey the consent letter. If there is a violation of the consent order, then the Pollution Control Board can prosecute such the industry. All these provisions we come across. We will discuss little later each and every the component of the crimes in India. Even Indian Penal Code also couple of the provisions we come across, wherein what is environmental crime? Environmental crime does not have a universally recognized definition. However, any activity which is detrimental to the environment and is aimed at profiting individual or group through exploitation, damage, trade or theft of environmental resources is called an environmental crime. The terms environmental crime includes a wide range of illegal activities such as illegally prescribed wildlife trading, crime against forestry and fisheries, illegal dumping of chemical or hazardous waste, smuggling of ozone depletion substances and illegal mining. Environmental crimes not only threaten wildlife including tiger, elephant, fish, rare birds, plants, but also our ecosystem through chemical pollution, massive deforestation and destruction of livelihood. Until 2014, environmental crime in India were not recorded by any of the government agencies. In 2014, National Crime Records Bureau released the statistic on environmental related offences of the more than 5,000 crimes against environmental. Nearly half were committed in Rajasthan alone. It accounted for nearly 50% of the total cases. This was followed by the Uttar Pradesh, Karnataka, Himachal Pradesh, Jharkhand, Maharashtra and Andhra Pradesh. NCRB data on distribution of environmental related offences across various states in India. Assessing the growth of environmental crimes can be challenging, considering that huge number of such crimes manage to escape the radar of the protective framework. mean to monitor and regulate such activities. Many of such activities are influenced by things like customs attention, coverage, efficiency, the cover changing scope of these crimes, change of smuggling routes, etc. Thus, many environmental crimes remains unregistered in spite of their high numbers. Less awareness of the nature and types of such a crime and different modus operandi of their execution are also huge contributing factors. NCRB statistic on environmental related offences in several categories in the year 2014. Illegal wildlife trade in India. The 2014 statistic of Convention on International Trade in Endangered Species of Wild Fauna and Flora 1973 shows a 5% annual rise in illegal wildlife trading across the world since 1974. Over the years, illegal wildlife trading has arisen as a dominant form of organized transnational crime that has endangered the lives of many wildlife species across the globe. Decline of habitat and a huge cross-border demand of wildlife derivatives had led to regression of many species of plant and animals. The various endangered wildlife species and their derivatives can be explained vis-a-vis the following. Tigers and leopards are hunted illegally for their whiskers, skin, bones and virtually every part of their body. Poaching of rhinoceros, horn, elephant are hunted for their tusks and ivories since they are giant creature. Inhuman technique like poisoning arrows are used to hunt them down. An otter's skin is the most popular in fashion industries where it is used as a trimming for coat and other garments. Musk deer is killed for musk pot, charus as kind Tibetan uses, salus, etc. Bile bear is kept in captivity and is tortured for its bile, a digestive liquid produced by the liver, etc. This has made bears as endangered species. According to the IUCN list of the vulnerable and red list of threatened animals, mangroves is killed for their hair which are used to make fine paint, etc. Significance in fence soli, butterflies are captured simply to be kept as a curious. India has a strong legal framework to regulate and control wildlife trade under the Wildlife Protection Act 1972, which prohibits trade in over 1,800 species of plants, animals and their derivatives. India is also a member of CITES since 1976. At just like many countries, the problem is not that of laws but of their implementation in and enforcement. Often the positive effort and concerns towards protection of wildlife are curbed by lack of political will and governance failure. There is an urgent need for awareness and action to bring wildlife trade within sustainable levels and stop all illegal activities that have threatened many species and pushes many other towards extinction. In this endeavor, trade records analysis of flora and fauna in commerce, a wide trade monitoring network, a joint effort of the WWF and International Union for Conservation of Nature 1976 work in close collaboration with the national and state governments and various other agencies to help them regulate and curb illegal wildlife trade and bring it within viable levels. It is believed that hunting in olden days was rewarded as a tiger were considered as a pests, it was a pleasure most of people used to enjoy. However, post-independence, hunting became accessible to a common man as well until the emergence of the wildlife law in the country 19th century, which brought about strict regulations and control to the killing and trading of animals, particularly the endangered ones. One of the major factors of existence and exponential increase in wildlife trade in India is the rich biodiversity, offering so much to the illicit traders with a little chance of being detected owing to the callous implementation of laws. India has about 8% of the world biodiversity and 2% of world's land, which makes in one of the 12 mega biodiversity nations in the world. Of the 2 million species that have been globally identified, approximately more than 1 lakhs have been reported to be from India. It has 10 biogeographical zones and 26 biotic provinces blessed with unique and rare species of flora and fauna. India diversity and its destruction in elephant poaching and ivory trade in India. Elephants evokes a strong emotional sentiments in the Indian population. However, despite being valued as gods and presented as a man's best friend on colluded, they are in disparate state in the wild due to the poaching and loss of habitat. Elephants are mainly poached for their tusk and only male Asian elephants have them. The voracious demand of ivory across the world has led to the selective hunting of the male Asian elephants, bringing down the ratio of tuskers to females to alarming level. The Wildlife Protection Society of India recorded the loss of over 121 elephants to poaching between 2008 and 2011. During this period, the authorities recorded 75 ivory and 99 prices of ivory, 69 tuskers across India. Between 2008 and 2011, whopping the nearly 100 elephants have been electrocuted. Poaching remains the major cause of threat and death of elephants. A new study reports that ivory trading is still prevalent in India, and the wildlife protection laws have just driven underground. Traffic in India conduct a survey found that Odisha, Assam, UP are the most active market for ivories and tusk of elephant. According to the report, Indian ivory is said to be exported to 40 countries around the world. Dr. Sekhar Niranjan, the head of the Traffic India, stated that current poaching hotspot also includes elephant rich habitat of the Western Ghats, the state of Karnataka, Tamil Nadu and Kerala. The wild elephant in India are engaged in the following activities: temple, elephants, ceremonial and festival use, begging, street elephants, tourist elephants, forest department elephants, used for patrolling the protected areas, circus elephants, zoo elephants. Just like elephants, bird trade is also spread across the country, and birds are trapped to be sold as pets and are often exported to countries like China. Species of voice etc. also exported. Even though trade and trapping of indigenous birds is prohibited by both Wildlife Protection Act and CITES, as a black market for 300 out of the 1200 bird species in India boom openly in the many places. Status of rhinos poaching in India. Unlike the African rhinos, the rhinos in Asian are known to have just one horn. The species found in India, rhinos, and like other species in Java and Sumatra have fallen prey to the hunting and poaching. However, the collaborative effort of the conservation and the governance have helped recover the population of Indian rhinos. In 1966, the population of rhinos is in Kaziranga National Park was 366, which was brought up to 1800. Against the poaching and discouraging poaching in general, between 2016-2015, just hundreds rhinos have been documented as poachers in India. At least rhinos poaching was shortly after Prince William visit to Kaziranga National Park, which brought the total number of poachers. India's trapping of birds is prohibited by both Indian wildlife protection laws and CITES. At India has been a home to a rather flourishing black market for birds. The laws designated for the protection of the birds is well intentioned, but just like all the other proactive laws are poorly implemented. The Crawford market in Mumbai is one of the largest market illegally trading some of the rarest and endangered species of birds. The Bombay High Court in 1997 constituted a committee to investigate the issue of illegal trading of birds in India and constitute measures that curb this. Since the committee is no longer active, black market for avian are mushrooming across the countries. The Nakas market in Lucknow and other places in Kolkata among the leading black markets for birds. The sellers in this market receive more than 600 birds from the trappers, which includes ducks, roosters, sarus, etc., which is the world tallest flying birds and endangered species. The captured birds are illegally transported in small boxes on trains. This results into bird getting broken body parts, contracting disease, etc. A result of which an estimated 60% of the birds die during transit. Of the 300 species of bird who are traded, 16 are among the oldest, most endangered, 36 are listed in the CITES, 6 are included on the red data list of endangered species. Until recently, the loss of habitat due to deforestation was the only threat to Indian tiger. However, a huge demand of oriental medicine outside India has resulted into escalation poaching and smuggling of tiger body parts across the border, especially China. According to a newspaper report, China's illegal tiger trade feeds on India. The severity of the tiger poaching has revealed. The Wildlife Protection Act 1972 imposes a penalty for an imprisonment up to 3 years and a fine up to Rs 25,000 for tiger poaching. If an offence is committed inside a tiger reserve, the penalty is a mandatory imprisonment of 3 years, extendable up to 7 years, and fine of Rs 50,000, extendable up to Rs 2 lakhs. In case of if there is a subsequent conviction of this nature, there is an imprisonment of 7 years and a fine of Rs 5 lakhs, which may extend to Rs 50 lakhs. The method of poaching tigers are similar to those of elephants. They include poisoning, steel traps, firearms, electrification. Poaching is prevalent across the country with Delhi, Rajasthan, Assam, Karnataka and Delhi being the predominant hotspot. In October 2003, the Environmental Investigation Agency reported that shipment of skins from 581 leopard tiger from the India to the other Tibetan countries have been intercepted. India saw the seizure of nearly 400 leopard and tiger, etc. Historically, tiger poaching in India, wildlife protection laws in India primarily the first Indian Forest Act was enacted 1865, then wildlife legislation of modern India was the Madras Wildlife Elephant Preservation Act enacted 1873. The Government of India enacted the Elephant Preservation Act. The Indian Forest Laws was enacted in 1878. The Indian Forest Act, which is consolidating legislation, enacted 1927. Wildlife Protection Act was enacted in 1972. Forest Conservation Act 1980. The Environmental Protection Act 1986. Supreme Court of India has been active in environmental conservation since 1965 and has passed various judgments on conservation of forests and safeguard of endangered tigers and elephants. A landmark judgment on protection of wildlife by the Supreme Court was given in the case of Centre for Environmental Laws versus Union of India, which the Supreme Court said that our approach should be ecocentric and not anthropocentric, rich when it comes to the protection of wild species, highlighted the judgment of M.C. Mehta versus Kamal Nath 1997. The Supreme Court said that under the Article 21, the human beings are not only entitled to a clean and safe environment, but also are obligated to protect it. Thus, protection of environment is a corresponding duty to the right to environment under Article 21 of the Indian Constitution. India has enacted many laws for the environmental protection which have constantly been recognized and reinforced by the apex court. What lacks is the monitoring of these laws at a grassroots level. People may feel happy and relieved on the seizure of illegal wildlife derivatives, but they are not involved enough as a community to protect it, considering the India's peninsula, its biodiversity and its demand in countries like China, Thailand, etc. Illegal wildlife trading and poaching can only be curbed by the collaborative effort of the government, activists and people. In order to encourage this, effort need to made to spread awareness amongst the lesser educated people about the importance of biodiversity to ecology and environment, and that human life is not the only life to value. Industrial violations. Apart from the troublesome flouting of legal framework for the protection of wildlife in India, it is the industries that break the laws meant for the protection of environment. From domestic to large scale, all establishments have been major contributor to the various kinds of pollution that exist. Instances like Bhopal gas tragedy, acid rain and declining oxygen levels in fresh water bodies are the consequences of the ignorance by the industries of the legal limitation that have been set up by the government in order to prevent this phenomenon from occurring. However, in the past 3 decades, the collated effort of the environmental activity and the Indian judiciary have been able to successfully implemented a number of principles through multiple environmental litigations. Most of these litigations were in the form of public interest litigations. Since environmental issues pertaining to diffused public interest rather individual injuries, the ability to invoke the original jurisdictions of the Supreme Court under Article 32 and of the High Court under Article 226 of the Constitution of India has remarkably contributed to the environmental protection. The courts, through the instrument of judicial review, have widened the ambit of substantive right to healthy, clean and unpolluted environmental by entertaining multiple PIL on environmental protection. The court have carved a way to processual justice without crumbling beneath the procedural burden. This was reflected in the case of Tarun Bharat Sangha Alwar versus Union of India, where a social action group challenged the legality of the mining license granted for mining a protected area of a reserved forest. In this case, the court observed that this litigation should not be treated as the usual adversarial litigation. Petitioners are acting in aid of the purpose high on the national agenda. Petitioner concern for the environment, ecology and the wildlife must be shared by the government. Through this judgment, the court highlighted the duty of the state to protect the environment as enshrined in Part 4th of the Constitution of India in the form of the Directive Principles of State Policy and Article 21, which also impart the right to clean environment. There has been a wide range of issues that have been dealt with through environmental PIL, while on some occasions ordinarily letters were considered as a petition by the court. On other occasions, media and newspaper reports. The judiciary through this litigations has developed certain principles over the years which have aided the development of a better regime for the protection of the environment. The polluter pays direct principles. The essence of the polluter pay principles is that the polluter shall be responsible for the damage caused by his omission. The high water marks of the development of the polluter pay principles is the absolute liability of the inherently dangerous and hazardous industries. The doctrine might come across as a deterrent one prima facie, but its deterrence is limited to the fact that it applies only at the remedial stage, that is after the damage has been caused. While formulating the principles of absolute liability in MC Mehta versus Union of India, the court stated that the power of the judicial review must be utilized to formulate new principles, remedies and strategies suited to the emerging issues of environment. While elaborating on the principles of polluter pays, the court said that the compensation should be proportionate to the magnitude and capacity of the polluting industry. The court intended to impose deterrence through such a dictum. Even though the principles was applauded, it was expressed by the experts that the liability should not be fixed without establishing nexus to the magnitude of the fault. This was the observed in the case of the Deepak Limited versus State of Gujarat, where even though the court did not depart from the essence of doctrine of polluter pays and the principles of absolute liability, it expressly stated that the compensation must have a broad correlation with the damage caused by the polluting industry. Another important principles, precautionary principles. The term precautionary principles is a translation of the German word which says that anticipate and prevent. Although the root of these principles are through German, it has been an integral part of the international environmental laws for nearly 4 decades now. The principles is an outcome of the perception that the amount of the effort that is going into the identifying environmental problems and finding their solution is much less than the pace of environmental deterioration. Thus, there need to be set of principles acting as an embryo on the existing developmental activity in order to protect the environment. One of the earliest mentions of the precautionary principles was by the judiciary by the United Nations Commission on Environment and Development in 1992 at Rio de Janeiro, also known as Agenda 21, which signifies its preventive approach. It states, in order to protect the environment, the precautionary approach shall be widely applied by stated according to their capabilities. Where there are threat of serious and irreversible damage, lack of full scientific certainty shall not be used as a reason for postponing cost effective measures to prevent environmental degradation. Precautionary principle represents a paradigm shift in the environmental judicial review. It has 5 key elements which are capable of preventing further damage to our environment. Anticipatory action: the government and the private agencies, communities and individuals all share the responsibility if anticipating the consequences of their actions and the environment. Right to know: the proponent of any product, service, plans or operations have the burden to disclose to the resident of the areas to be affected consequences of such operation in terms of potential health hazards and damage to the surroundings. Alternative assessment: the acting organization are bound to make an environmental impact assessment of their activities on the target areas and find out the least damaging alternatives in order to protect the human health and environment. Full cost accountable: when evaluating alternative measures, it is dealt to evaluate the reasonable foreseeable cost, including the cost of disposal and health cost for the people living in the nearby areas which are likely to be affected by such operations. Participatory decision making: not only should the people be well informed of the consequences of any developmental activities on their land, but also they should have an equal say in deciding whether or not such activity should be carried out on their land at all. The proponent companies and organization must not act without a unanimous consent of the concerned community of people. In India, apart from the multiple environmental regulations, the major legislations that exist are the Water Prevention and Control of Pollution Act 1974 and Air Prevention and Control of Pollution Act 1981 and the Environmental Protection Act 1986. This legislation aims at regulating and whenever possible restraining the damage that can be caused by the pollution. The precautionary principles has not been expressly mentioned in any of the current legislations and regulations. However, the Supreme Court of India largely referred various international conventions, especially Stockholm Declaration, Rio Declaration, Rio plus 20, Rio de Janeiro, while interpreting the various environmental laws in India. Primarily, some of the important principles such as polluter pay principles, as I discussed earlier, precautionary principles, sustainable development, intergenerational equity, intragenerational equity, all such principles have been relied by the Supreme Court of India in several decisions so as to protect and prevent and improve the environmental resources in India. Thus, Supreme Court role in preventing environmental crimes considered to be commendable despite of the existing legal system in India. One more important principles have been applied by the Supreme Court, that is public trust doctrine. As per the public trust doctrine, it is a Roman principles wherein all the natural resources which are belonging to the state, and it is the duty of the government to administer those resources for the benefit of the community as a whole. While doing so, if the government misappropriates, misuse or misgoverns these principles, then judiciary have uh, power to rectify such mistakes. In several cases we come across recent coal block allocation case, MC Mehta versus Union of India, couple of the cases wherein Supreme Court of India applied this particular the principles public trust doctrine. This public trust doctrine considered to be one of the emerging the principles under the environmental law, wherein it mandates the states responsibility to govern these resources in a wisely and proper manner, so that lot of criminal activity can be prevented. When you say about environmental crime in India, we have both crimes, we have both remedies we can provide. One is tort remedies and the public law remedies. Especially under the public law remedies, even Indian Penal Code also couple of the provisions have been provided under the Indian Penal Code which prevents environmental crimes, and tort remedies one can seek the compensation from the party. Now we are going to discuss some of the important penal provisions under various environmental laws. See, one of the important aspect of environmental laws, we do not have a comprehensive environmental laws, although the Government of India after the Bhopal gas leak enacted Environmental Protection Act 1986, which covers each and every aspect of the environmental the problems. Now we shall discuss few the provisions which deals about the penalty clause. Criminal liability of polluter under Indian environmental laws, especially the Water Prevention Control or Pollution Act 1976, we come across failure to comply with any direction given by the name of the State Board of Prevention and Control of Water Pollution under section 20. For that purpose, punishment up to 3 months or fine up to rupees 10,000 or both, and in case of failure to follow such penalty, the fine up to 500 per day. Likewise, for destruction, pulling down, removal, injury or any pillar, post, stake put by the Pollution Control Board, for that purpose imprisonment for a term up to 3 months or fine which may extend to up to 10,000 or both. Where for the grant of consent under section 25 and 26, any person who willfully alter, interferes with a device mean to measure and monitor environmental phenomena, punishment is imprisonment for a term up to 3 months or fine up to 10,000 rupees or both. Introducing poisonous substance into a stream or well or altering the outlet for discharge of sewage without the permission of the State Board is the contravention of section 27 and 25. For that purpose, punishment is an imprisonment of 1 year and 6 months, which is extendable up to 6 years, and fine. For subsequent violations, the imprisonment shall be a term not less than 2 years, but which may extend to 7 years. Thus, we can say that the Water Act, which provides couple of the penalty the provisions, wherein Pollution Control Board or any citizen after giving 60 days notice can file a suit against airing companies, when even the criminal liability can be also imposed on director of the industry who violates the consent order. However, director can escape from the responsibility by proving that act happened beyond the control. Another important legislations, the Air Prevention and Control of Pollution Act 1981, we come across penalty provisions under this act is somehow similar with that of the Water Act, wherein here also couple of the provisions we come across which makes violation of Water Act punishable under different the provisions. And one more important the enactment, the Environmental Protection Act 1986, considered to be umbrella legislations. This particular legislation gave lot of power to the central government to make rules and regulations in order to tackle each and every problem arising out of environmental aspect. For example, under this law, failure to comply with or contravention of this act, in respect of the failure or contravention, the punishment is imprisonment which may extend to up to 5 years or with a fine extendable up to 1 lakh with both. In case of continued offence, additional fine of rupees 5,000 per day will be imposed from day of the first conviction. Therefore, we can say that apart from these 3 legislations, even under the Forest Conservation Act 1980, diverting the forest for non-forest purpose amount to an offence. Then any activities within the reserve forest, protected forest, the national sanctuary, the wildlife sanctuary without the permission of the designated authority amount to an offence. Likewise, today we have Biodiversity Act 2002 and waste management rules. Each and every rules imposes penalty the provisions in contravention of the laws. Likewise, the Factories Act, the waste management the laws, which made obligation on the part of the municipalities or the occupier of the industry to follow such regulations properly. If they do not follow, the concerned authority can prosecute such bodies. Therefore, we can say that environmental crimes considered to be very important aspect of the law, which can be implemented properly. The offences has been provided, even though very less punishment have been provided under those legislations. By implementing those the offences, implementing those the provisions would send a strong message to the society in order to tackle the various environmental offences in India. Unfortunately, in India, we consider that these offences are very small offences, people won't pay much attention, but the moment we allow these offences to continue, a day will come most of the environmental aspect would diminish. Thank you.